Well, the application to sit as a recorder is, in your cases, as I see it, the first formal application anyone has made to the JAC. And the fact that you are making the application demonstrates that you have been at the bar or been a solicitor for a substantial period, and that having been an advocate, you feel the call to move your career, at least part-time, into a different area. And I suppose we all get to the point at which we've seen the job being done sometimes well, sometimes rather indifferently, and sometimes with utter brilliance. And we say to ourselves, one way or another, not only do I think I could do that myself, but also I think I'd really like to do that job. And it is a great shame that this is the first competition for recorderships that's been held, I think, since 2011, which, if we could do anything about it, I assure you we would have done. Now, of course, the job of sitting is a completely different one to the one you've been doing, albeit it's in the same court, and even though you've been doing it for a considerable number of years, because instead of being, as an advocate, paid to speak, you are in the main paid to keep your mouth shut. And it's a very wise person who, detecting that they had a tendency to shoot questions first and ask questions later, made a sign for themselves on the bench reading "shut up" in block capitals, which they placed in front of them on the bench where no one else at least could see it. And it's a strange thing that, having sat through a million homilies from judges, start of a case about not speaking to jurors' families, for example, and thinking you could do that in your sleep, how tongue-tied you become when you first have to do it yourself. And when the great moment comes and the last defence speech has taken place, instead of breathing a great sigh of relief and going off to the pub for a relaxing drink with your mates, it's now time for your hard work to begin. But of course, in order to avoid the utterly embarrassing, flesh-creeping, page-turning summing up, which we've all seen regrettably, you'll have been hard at it crafting your remarks. And then the verdict. It can be very difficult to sentence someone to prison when you've felt throughout the case that they were a little unlucky to be in the dock in the first place, or when you feel that they were as much a victim as a complainant. But sentence you must, and sometimes you'll have to harden your hearts and do something you really don't like to do. And you'll not always get the support you need. At the recorder's course, I was assured that I'd be in court with an experienced clerk. 9:30 came round, 9:45, 10, 10:15, no clerk. 12:29 came round, and an apology of a person shuffled into my room with bands that were crushed and bent, and a wing collar about 2 sizes too big. "Oh, I'm sorry, Your Honour," he said, "but I haven't done this for 5 years, but we've got so many staff on holiday and some are ill. I've been pressed into service, thanks a bunch." But having said that, it's a great and satisfying job. You will learn so much from the training, which is excellent, and you will make firm friends for life as a result of mucking in together. Be under no illusion that I know the JAC have recognised the extent of the task that they have in mind. There are no bars. Wherever you come from, whatever your background, you will get a fair chance in this competition. Now, I appreciate that some will not succeed in their applications. If that happens, please do not despair. Think carefully about how the interview went from an objective perspective. Get the feedback and think about that too. Do give it another go, and your experience will stand you in good stead for a second or a third go at it. Do not despair. But of course, we are here to help you to get the very best of your application. I'm afraid I have to go on to another event now, but you're in very good hands, and may I wish everybody who is here the very best of luck in the competition that is ahead. Thank you.
Well, welcome to everybody. It's absolutely fabulous to see so many people here to come to this meeting, not least to hear Alistair's inspiring introduction. I just want to put a bit of an E&D context onto all of this. I took over being chair of the Equality and Diversity Committee of the Bar Council about 18 months ago, and I've been working very closely with Sam Mercer, who works here in the Bar Council as head of E&D and is largely responsible for putting on today's seminar over the last months, trying to secure a better view about what's happening on the equality and diversity front. Well, the really good news is that actually recorders are amongst the most diverse judicial posts. We're relatively confident that that is the position. I say relatively confident because we're working closely with the Judicial Office to get a better view on actually what the statistics are across the judiciary. But if you do look at those statistics, you can feel confident that this is an area where equality and diversity in terms of selection is going reasonably well. I'm really pleased to be able to say that because when I applied first to be a recorder back in 1997, it might have been 1996, I went down to the old Lord Chancellor's department to be interviewed, and there were 3 people whose names I didn't know who interviewed me, and after a while they produced a file and they started questioning me in the old-fashioned way that used to happen because the Lord Chancellor's department kept a file on all barristers, thinking that they might one day want to become a judge. And they pulled out a piece of paper and started questioning me about a time in which I'd had a spat with a judge, in which I was entirely in the right, of course, but it managed to make page 3 of The Sun, and the cutting had got into the file. I wasn't taken on. But within a year, I was sent a letter saying, "We'd like you to apply again. We think we ought to do it the equal opportunities way." And that was really the beginning of, it was before the JAC, thinking that equal ops was really important in the process of recruitment. And I can certainly tell you, because I've worked very closely, and my committees work very closely with the Judicial Appointments Commission, that there's probably, in my experience, nobody within government that takes the idea of equality and diversity more seriously. They look very carefully at their statistics, they think very hard about the programmes, they talk to the E&D committee, and they are absolutely committed to getting a diverse judiciary. And it's very much a feather in their cap that they want to do it. It's a difficult task. Our role within the bar, though, is to encourage people from all walks of life to have a go in this competition. And that's partly why this seminar's on now today, and you're going to hear some more ideas about it. Just a few that I want to share with you. First of all, it's a really good idea, if you can, to get into court with somebody and sit next door to them as soon as possible, just to see what it's like from the other side of the bench, the bar. Secondly, think about mentoring. Whether you make it this time around or not, it's a good idea to find somebody who's got a judicial appointment, could be another recorder, to help mentor you. We have, and the mentoring programs we're trying to develop here within the Bar Council, keep your eye out open for those as well. And if you have E&D problems of any kind, please be in touch with us.
Thank you. Good evening, everybody. Tonight I really want to focus on giving you an outline of the application process that we're looking at using for the forthcoming recorder exercise. First, focus on the overall process, but also on some specifics. So I'd like to talk a little bit during this time about the self-assessment and the references in particular, where we've made some slight changes to previous exercises. Hopefully many of you will have heard much of what I'm going to say. Hopefully many of you will have heard much of what I'm going to say through the updates to our website and the notifications that we've been sending out.
Can you speak up just slightly?
Yeah. So the headlines on the exercise. We're expecting to launch the exercise in April. The precise date is still to be confirmed on that, but keep your eyes peeled on the website for more information. The number of vacancies is also still to be confirmed. But what I can tell you now is that there are likely to be roles across all circuits in the UK and in both crime and family. Importantly, we, as I think Robin referred to earlier, we do anticipate that this might be the highest number of applications that we've received for an exercise. We're expecting somewhere over 1,500 applications, but obviously, as you can understand, we don't know exactly who will apply, but we are expecting a very high level of interest for this. Important to note as well that candidates can apply for both the family and crime jurisdictions, but you should obviously think very carefully before doing that and decide whether you have the skills to be applying for both. Don't just try and put in a hopeful application for one. Certainly, if you think you have the skills to apply for both, then by all means do. So, first of all, I just wanted to start by talking about the competencies for the positions. The competencies have changed a little since the last recorder competition and have changed over the last couple of years. We've now aligned the competencies with those used across the rest of the judiciary. So they take a slightly different format to previous exercises, but the important thing is what we're using now is specific to the role of recorder, and there's actually a slightly different framework for recorder family to that which we're using for recorder crime. The point to note though, hopefully many of you will have seen these already. They've been on our website for the last month or so and are still on there, so I don't plan to go into them in detail today, but do have a look and certainly become familiar with those before you put in your application. It's important to note that those frameworks describe the behaviours of an effective recorder. They're not suggesting that you have to have all of those behaviours right now. It's been taken as those are the behaviours that you will have, or that an effective role holder as a recorder will have. So as an applicant, you'll be expected to demonstrate the ability to acquire those behaviours if you don't already have them. Just moving on now to the application form. That's the really the first place where you're going to need to address these competencies. You'll be expected to write against each of these competencies in your self-assessment part of the application form and give examples of where you've demonstrated behaviours similar to those being requested. If you're not familiar with competency-based application processes, then it's well worth researching it and looking up on the internet. There's a lot of different guides to how to follow competency-based approaches, but a simple way to approach it is following the SOAR model, so SOAR, where you describe the situation you faced, what the objective was, the actions that you took, and the result. And including in that result, worth saying if you learnt anything from that. You should make sure to choose examples that are appropriate and relevant to the role of a judge. Also, think of examples that set you apart from the crowd. Clearly, everybody else who is applying will meet the minimum requirements, so there'll be at least 7 years qualified as a solicitor or a barrister. So you need to think what skills and experience you have that sets you apart from those other people, and use those examples in your application form. Don't be afraid at this time to blow your own trumpet. It's very un-British, but it's a very good thing to do at this stage. And if you're struggling to do it, then ask other people who know your work if they can help you out with examples that you might use here. And on that front, it's well worth starting to prepare these examples now. There's nothing stopping you from doing that. Moving on now to references, it's at the application point that you also need to provide reference details. Important to note though that we won't contact those referees until much later in the process, and that's when and if you get invited to a selection day. So you give them at the start, you give us the details at the start, but we will not do anything with those details at the very start, and it will only be the candidates who are invited to interview who we apply for references for. you'll need to choose 2 people to give as referees, and there's slightly different criteria depending on your status. But if we took it that if you don't currently hold a judicial office, then you need to nominate 2 professional referees. And what a professional referee means are 2 individuals who can comment on your professional expertise. So it doesn't necessarily have to be somebody who could be classed as your boss. It's just somebody who knows you very well and knows your work very well. Now, it's only if you hold judicial office, so if you have a fee-paid appointment of any type, that you need to nominate a judge as one of your referees. So just to clarify, there's no need to name a judge as one of your referees unless you are already a judge of any sort. So if you're wondering who to choose, just to restate there, it's somebody who knows you or your work very well, and somebody who will be able to give concise evidence of how, and examples of how you meet the skills and abilities for the role. It could be a client, it could be another barrister, it could be a head of chambers or somebody else in your chambers, but it's your choice, it's at your discretion who you choose. But importantly, we won't be swayed by the status of that person, so you won't get more credit by naming a judge, for example, because they know your work very well, than you would do if you named somebody else who knows your work very well. It's more about what is written about you rather than who is writing it. So once you've filled in your application, the next stage is the qualifying test. So everybody who meets the basic eligibility, so the statutory eligibility for the roles, will be put in for the qualifying test, and we'll have an opportunity to take it. The qualifying test is online. It's a multiple choice test, and it can be taken from a location of your choice. So from your computer, anywhere. There's a change to the test from previous ones in that there's now going to be 3 parts to that test. It won't be 3 times as long, but the test will be split into 3 distinct parts. Those parts are, the first part is legal technical, second is situational judgment, so putting you in situations you might find yourself in as a judge, and the third part is a critical analysis test. So that's more pure analysis of information that's put in front of you and then answering some questions about it. So that last part is not a technical legal test at all. So the first 2 parts of that test there will be specific different tests for if you're applying for crime or applying for family. If you do choose to apply for both crime and family, then you will need to take both parts of both those tests. So that's an important thing to note if you are choosing to apply for both exercises. To proceed past this stage, you must score beyond the minimum standard in all 3 elements of the test. The reason being that we're looking for people who are all-rounders and who aren't just legal technical experts, but who can perform to a reasonable level in the other areas as well. Of those remaining, those with the best combined scores in the 3 tests will proceed to the next stage. Because of the numbers who are expected to apply for this exercise and a desire for a more gradual reduction of numbers than what we've had previously in selection exercises, we're introducing a second stage of shortlisting for this exercise. That second stage is still in development. The drafting judges are working on it as we speak, but it's likely to include a written assessment, again conducted online, and a review of your self-assessment form at that stage. So the written assessment will be based on a situation that you may find yourself in as a recorder in that role, and it will require a typed response from you, so an open text response where you have more of an opportunity to demonstrate your judgment, and there will be a limited word count to that response. So this written piece of work and your self-assessment will then be reviewed by the selection panel and scored by them. That panel will be a judicial member and an independent member on that panel. The panel will then consider these scores alongside your qualifying test scores in order to get a holistic picture of all those candidates who've proceeded to that stage and to make the best possible decisions on who should proceed to the final selection day stage. Getting towards the end of the process now, but moving on, those who move on to the final selection day stage, which is the next stage in the process, we will invite around 2 candidates for every vacancy that we're recruiting for. So a ratio of 2 to 1 against the vacancies. And at this stage we apply for the references for all candidates. So the final stage in terms of the hurdles that you might need to go through is selection day. For any of you who've gone through this previously, that will be quite familiar, but so it's similar to what we've done for previous exercises. So it will comprise a role play where you'll put in the position of a recorder, whether that be in family or in crime, and you will need to act out based on some case papers that you're given in advance on the day. You will need to act as the judge and conduct a case or a couple of cases as the documents indicate. There will be actors involved as well, but it's the best chance for you to be able to demonstrate whether you have the skills to do the job. There will also be a panel interview with a judge and 2 independent panel members. And after that stage, all of the information that we have from the start of the exercise through to that point will be reviewed in order to decide who are the best candidates to proceed to be recommended. So that's the full process. I think you'll agree it's likely to be a difficult process, but quite necessary in order to whittle down from the large numbers we have and to choose the best at the end. I'd echo what someone said before me about getting along to observe a relevant court, sit alongside a judge if you can, use your contacts if you have any. Do sign up to the notifications on our website. If you sign up to be notified, then every time we update something, you'll be made aware. And do keep an eye out for the updates on that. So, good luck. I'll answer that question in a second, but maybe a wider question. It will be within a certain window of time that you have to complete it. So, maybe a 5-hour window, for example, as yet to be determined on the day once it's been decided. I believe the way it's being set up, and we're still road testing this at the moment, is that it will be in different sessions, if you like. So you would take the critical analysis test, and then it will stop, and then you take the other one, the behavioural, and then you take the technical, or in whichever order you choose. And my best estimate at the moment for the timing of each of those is that they would be about half an hour each. There is always going to be an element of challenge in terms of time in order to differentiate between candidates, but it's not meant to be simply a speed test.
I mean, that's part of the reason for the road testing, because if everybody comes back and says we can't get beyond question 22, then, and this happened on the DJ exercise I did, we had to modify the test. But you'll also understand, and there's a huge controversy around windows. People have childcare commitments, they have court commitments, If you leave it open for 3 days, it actually possibly enables somebody to take the test and then tell somebody else what's in the test. And we've certainly had rumours that that's happened on occasions. And the other difficulty with giving people lots of time is, in theory, they could go and pick, if it was crime, go and get their archbold down from their chamber's shelf and look the answer up. And one of the competencies is efficiency. So you are expected to be able to marshal your thoughts relatively quickly, but we hope not onerously so.
It's not planned at the moment, but it's certainly something we can look into.
What I'm not sure about, I mean, there have been, the Deputy District Judge Civil was a multiple choice, wasn't it, I think, and there's one other that we've done.
Yeah, there's been a couple of others.
Yeah. Have a look. I'll distribute my email. I'll try and make some inquiries for you. The problem with a change in system, and this is that there are always those that feel disadvantaged if there aren't mock tests up there. So, for instance, the Northern Circuit had the first ever qualifying test for recorder, and the Midland had the second, and the South Eastern had the third. And by the time the South Eastern competition came along, there were 2 previous tests, Midland and Northern Circuit. And the Northern Circuit have always felt aggrieved that there were no tests for them to attempt because they were the first group of people. And that is one of the problems with trying to develop what I think the JAC hope will be fairer tests that will test the competencies that are most relevant to judging, because they're not necessarily the same as being an advocate. There's a completely different type of advocacy in being a judge. I think that's what they're looking for.
I think it's the latter part of your question, as you stated. It is going to be decided to some degree based on the performance of the number of candidates who take that test. So a greater number of applicants will drive the pass mark up inevitably. Yeah, so it will have to be decided later. The first question, there will be, and this will be made clear within the test itself, there will be some questions where there is a next best answer as well as a best answer, because some things aren't clearly black and white and can't be absolutely one thing. There might be a next best answer if you took a slightly different view on that, but there will inevitably be a wrong answer as well.
I suppose on the multiple choice, the model answer is going to be the only one which is acceptable as right, isn't it? Is that the way it works? So you're given the answer, I think, in this form of multiple choice.
So we've taken different approaches to this over the years with the previous tests, but at times we have produced the full marking schedule for previous tests. But generally, our approach now is to provide a feedback report which gives a more general approach and gives more of a general feedback on performance in the test. But you'll be able to see everything that is published on the website. But anything that we produce would only be produced once the outcome of the recorder competition is known. There's separate tests for the first 2 elements of the multiple choice test, so all except for the critical analysis. There are separate elements for family and for crime, because perhaps, as you can imagine, the behaviours that you might need to demonstrate in a certain situation would be different in family to what they might be in crime in many areas. So in some ways that's where you need to exercise caution, that you will have to do nearly twice as much work in order to put in an application for both family and for crime.
But presumably you only need to pass one to go forward, do you? I mean,
your
go into one stream or the other or both.
Yes, they'll be treated separately in that sense. So you'd be applying for the 2 different elements.
Yeah, okay.
That's impossible for us to answer, I'm afraid.
My experience was as follows. I had an interview with a judicial member, the circuit judge, because we always have the judicial member, the tier above. And I had a lay member who I think came from sort of human resources type background. He's very intrigued to know about all my extracurricular activities. The intellectual capacity questions tend to come from the judicial members, but not necessarily. I think if we're going to move, as we apparently are going to more situational questioning, it will almost be inevitable. It will be the judicial member who will say, right, this is the scenario. You've read the crib sheet or the materials. Give me your ruling on hearsay, or give me your ruling on bad character, whatever it might be. So, I think a big tip, if having seen some situational questioning in other competitions, is to think judge the moment you walk through the door. Now, I had a role play as well, and the judge who was marking me for the role play said, once you walk through the door, I'm your usher, which was quite disconcerting. And then I had actors that were being irritating in a variety of ways, either shouting out in court or swearing from the public gallery. And what they were trying to get you to demonstrate was that you could control that situation. I don't think there's a right or a wrong way of doing it. There are a few elephant traps, so keep your wits about you. I had somebody asking for an indication on plea. He was currently pleading not guilty and wants to sack his counsel, so you think on your feet a little bit. But I think it's quite difficult sometimes for people to appreciate that the role play is something which is looked at very closely, particularly by the judicial members. It shows when people, I think, have got an instinct for the job, but we also look and think about people who look as if they're trainable. So in other words, you might get 60% of it right or 75% of it right. You don't have to get 100%, as long as your instincts appear to be right. And sometimes they're not always right answers, or sometimes a candidate comes up with a view and none of us were expecting it, and we think, well, that was actually quite a good way of dealing with it. So, I mean, for those of you who do crime, I get bad character applications quite often before the juries, after juries and panel, before any evidence is called. And the top tip I was given by a full-time judge is do your very best to decide as little as possible, and when you do have to decide it as late as possible, because quite often these things melt away by the time the trial's got going. So if you can bring that kind of practical experience. I also think it's really important. I know criminal practitioners think they know everything about crime if they're applying to sit as a recorder, but I had to sit in for a week because I was regarded as civil with a judge. And when I went on the residential course, definitely the civil practitioners performed far better than the criminal practitioners, because the way the course is devised, you start with a knock on the door from an usher who says, I've got a member of the BNP who's refusing to try any case that involves an ethnic minority. So they start with the behind the scenes stuff, and they take you over the 6 days. It's quite a clever course through almost everything that can go wrong in a trial situation, from jury empanelment to people being ill to witnesses mentioning previous convictions. And they get each of us given a little script, and nobody else knows. So I had to shout some obscenity from the public gallery on my course, and it made the candidate next to me jump out of her skin. She had no idea I was going to say something. So the advantage we had as civil practitioners was that sitting in. So if you can do it, I know it's difficult for busy practitioners, but because it starts with the pre-trial stuff, you don't see that when you're counsel. You don't see ushers coming with questions, because you're the other side of the court. But if you sit in with a judge, you do see those things happen. And equally, I'm sure when a judge is saying to a jury, doing a little homily about don't go on Facebook, don't go on Twitter, it's a contempt of court, it's white noise to criminal practitioners. You're busy untying your brief, thinking about your first question. But if you see a judge do it, then you can deal with that kind of situation. So if there is a question in the situational questioning or in the role play around some pre-trial management decision around jury empanelment, and you've seen it done, you retain it. But I do think that a lot of the criminal practitioners for the first couple of days struggled because they, as practitioners, they're not listening. I know it sounds very odd, but it's understandable to me, to what the judge does in terms of his interaction with a jury. But when you sit as a recorder, that's your job. You have to take control of that courtroom.